legal department with David, and you've started doing the RREAF Academy, right? So you've been through some weeks of RREAF Academy, and last week you guys talked about term loans, business lines of credit, commercial real estate loans, SBA loans, construction loans, auto loans, bridge loans, equipment financing loans, inventory financing. So today we're going to talk about secured lending transactions. And those comprise of acquisitions, development, operating, and construction lending. So a secured transaction is when a borrower agrees to give a lender a security agreement that the lender may take the borrower's collateral if it defaults on the loan. So I provided a visual on the second page, which will show the borrower has the ownership collateral rights, and the borrower it could be an acquisition loan. It could be it already has rights in this collateral and is extending those rights to the lender in exchange for a loan. So what a secured transaction is the lender is able to step into the shoes of the borrower and become the new owner of that collateral. And if certain defaults occur, the main one being non-payment of the loan. So the bank relies on revenues from income-producing businesses to grow and prosper. They're looking for deals to get involved with borrowers who have collateral or who are looking for deals to acquire. It's what we do a lot in commercial real estate, is looking for loans, looking for deals. And we're doing our underwriting. We're also partnering with lenders to provide a portion of that risk and enter into new deals. So there's lots of different ways to secure lending and look for deals. And banks will face state and federal regulations with any kind of secured lending. And they're faced with different requirements that they will let the borrower know in those deals. So that's where banking underwriting comes in. And we'll have partnerships with lenders and communication always with our underwriting, with their underwriting, and the deals will make sense to both of us. The bank will look at the underwriting, see the income, and they will lend depending on what those numbers say, anywhere from 50 to 80% leverage. So the lender will extend term sheets based on their underwriting, based on our underwriting of those deals. So depending on the collateral, there might be different lending scenarios that occur. The lender wants to make sure that their interest in the collateral is secured. And how that happens is by the loan documents, the promissory note, and the security instrument. So those two things will secure their interest in that collateral. And both of those are signed by the borrower. And if the lender needs to foreclose on a deal and step into the shoes of the borrower, they will need those two documents to go into court and pursue those rights. And then, depending on the situation, different things will occur. So we're also going to talk about like deal timing and priority, and the loan documents in general, terms that you'll find in the loan documents, and then credit risk that impacts interest rates. Deal timing, that will just depend on what's going on in the market. So our normal process here in commercial real estate will be that we'll see deals out on the market. They're offered, but collateral, some borrowers already have that collateral and just need extra funds for whatever reason. A good example is you all need a car. So you may have the car, you may go out and go buy a car. That collateral will most likely require a loan unless you guys have the cash. But even if you had the cash, you could buy the car and then go secure lending to have extra money in your pocket to do whatever you want. So a car loan is secured by a bill of sale and a promissory note with the lender and a security instrument. And the bank will prepare loan documents to secure that interest. They may have to repossess it if the borrowers do not pay the loan. And that's for auto loans, but in real estate, there's deeds of trust, and mortgage. Each state says different terms for what the security instrument is called. So the title company may impact dates or timing for deals. So it just depends on the deal at the time. And then loan documents in general. So for commercial real estate, a lot of the loan documents that are required are closing certificates. So that would be like authority documents. So in a loan transaction for a car, you would provide your social security number, your name, your consent is your signature. In commercial real estate and entity commercial lending, there will be an entity and it will have an EIN, it will have a certificate of formation, it will have authority documents that the lender will require to show authority to enter into the loan documents. And the lender will also require the security agreement, the promissory note, assignments of accounts, contracts, and management. Depending on the security interest, it will depend on what they're assigning. So they may assign management contracts for property management, for construction management, for any kind of underlying contracts that are material to the deal. And there will also be a guarantee. Not always will a guarantee be required by the loan documents, but depending on the asset, the collateral, the lender may require a guarantee of the loan proceeds. So there might also be an indemnity agreement, which is, in addition to a guarantee, there might be an indemnity agreement, which means that the lender is worried about certain risks associated with the deal at hand. So that might be an environmental indemnity, which in a land loan, there might be issues with the soil, issues with some kind of environmental risks on the property. In multifamily, it could be mold, it could be asbestos, and so there's different things that can materially impact the lender's interest, and in a way to reduce risks is to enter into an indemnity agreement, which will allow the lender to recoup costs from the borrower or the guarantor if those matters are found. So there's also the loan agreement, which will describe the relationship between the borrower and the lender. So that might include terms of loan repayment, terms of interest reserves. So an interest reserve might be required by the lender if the borrower may not have the funds available to pay on the loan. So they'll require like a 6-month, maybe a 12-month interest reserve. So the lender is ensuring that they'll get at least the interest payment when they're trying to collect on the loan. And that will be like a cushion. They may even have requirements that they could even pull the entire loan. So if the borrower is not paying even the minimum amount due, they could just pull from the interest reserve the lost payment. And so that will give the lender a buffer to then be able to have the time to repossess or collect on the collateral. The loan agreement may also have terms of debt service coverage ratio or loan to value requirements. There might also be a confession of judgment, which makes it easier for the lender to repossess the assets. So a confession of judgment would just say, I am the borrower and I have entered into these loan documents and I agree to certain things in the event of default, non-payment primarily, that they are able to easily repossess the property. There's also grace periods and notice periods requirements in the loan agreement. So it might give a 10-day grace period for non-payment. It might have grace periods for events of default. And an event of default could be so many different things. It could be that the income of the asset, whether that be a multifamily property that has rent income, that has fallen. So then there's not as much income coming in to the apartment complex, and so the debt to income ratio, the debt service coverage ratio has increased. So There's also interest rates, which are rising right now, so it definitely impacts lending and how much risk the lenders are wanting to engage in. There's also construction issues. Right now, a lot of our assets are facing supply issues, whether that be lumber, whether that be concrete, and who knows, we may face more supply issues in the future. It's hard to say with this market right now. And then, I mean, every deal is different, and every economic market change can impact interest rates, can impact where banks want to go to look for business, whether that be development, whether that be existing multifamily, whether that be auto loans. So it's important for borrowers to be flexible and look for assets that are revenue generating and use leverage to maximize their portfolios, either individually or business. Generally, do you guys have any questions about secured lending?
How does the collateralization process work differently in a real property secured loan versus a personal property secured loan?
How does the secured...
How does the collateralization process, how does that process work? What different documents are involved? How are those liens filed and perfected?
So like a personal loan?
No, personal property.
Personal
real
property.
property.
Oh, okay.
In a
So
secured lending transaction.
In a secured lending transaction. So there's real estate, and then there is personal property. And how to secure those different collaterals are different. In the real property, there is real property records of the county. And deeds are filed in those counties. And then mortgage or deeds of trust are filed in succession. So in order to secure the interest on the property, the lender, after the deed has been filed from the seller to the buyer, the lender will step in and file their deed of trust immediately after, or mortgage, whatever it's called in the county. So they will file this notice to all the world that anybody can log in and see there is this deed of trust or mortgage on the property. So if somebody is selling me this property, I need that deed of trust or mortgage secured or released, paid off, because otherwise that lender, if it doesn't get paid on that mortgage or deed of trust, will step in and repossess the land. And as a landowner, you wouldn't want that. I mean, you're wanting to buy the land and have all possessions of the land. In personal property, it's easily movable and it's harder to secure that interest. There is an entire law book on securing personal property, and lots of lawyers spend their entire career just on that, personal property and fixtures, and there's different definitions of like, what is this type of property? Is it movable? How can I secure my interest in this property? So for personal property, there is a filing system. It's called the UCC filing system. And you have a UCC statement, financing statement, that is executed in addition. You could just have a loan for personal property. But with a lot of businesses, including multifamily, in addition to the lender wanting to secure their rights in the real property, they also want to secure their rights in the personal property located on the premises as well. So multifamily, they might have ellipticals, they might have treadmills, they might have office equipment. So the multifamily lender will want to ensure that those personal property items are secured, their interest in those. And those are secured by a UCC financing statement filed in the UCC records. So you'll need that in addition to the promissory note in order to repossess the personal property collateral.
And a security agreement, right? In a personal property setting, we need a security agreement
Yes.
executed by the debtor
Yes.
to perfect to attach the security interest, and then to perfect it, we either need a filing or we need some other form of attachment. As you've indicated, it's a bit more of a complicated area. There are places to file, there are ways to file, depends on where the collateral is deemed to be located and all that sort of thing. That's Article 9 of the Uniform Commercial Code. And Tabitha's right. It's an entire separate area of law that in secured transactions, especially at the banker level, people really get involved in it, right? They really know about it. Your car is a different one. So let's talk about movable collateral as in vehicles and how those sorts of things get secured generally. And you can even talk about aircraft for a minute as a special example of that. You've been involved in some of that too. So talk to us a little bit about how a security interest of a secured lending occurs with a fleet of vehicles, not just an individual's car, but a fleet of vehicles. How do they secure that?
Well, a fleet of vehicles, that's harder, but like individual vehicles will have titles. Everybody's probably seen a car title, and in order to, with car titles specifically, physical possession is like the highest form of securing your interest in that. So a lot of times, if you do have debt on a car, the lender will not even allow you to have the title. So they'll keep the physical title of the car in their possession, and it will be in their name, but you'll have like an interest in it, and then that lien will be removed from the title once the note is paid off, and then the lender will send you the title.
Right, so in that situation, the title, in a title situation where there's a title record that is issued by a governmental agency or organization or something like that, we'll talk about aircraft in a second.
Yeah.
You'll actually have the lender register as a lien holder on the title, physically on the title, right? There's a special place for the lien holder. It gets registered on there, and once it's registered not only on the title, but it's registered in the records. So anybody that came along that wanted the title transfer, even if they didn't have the physical title, the record holder could simply look at the record and go, well, that's subject to a lien. It's in the system, right? It becomes a matter of record that you can figure it out. And that way, it doesn't get transferred to somebody else. I mean, a buyer would know, oh, wait a minute, this already has a lien on it. Well, you're going to have to go pay that guy off because I'm not taking the car from you, paying you money. And then I still have a lien on the property, right, on the car. And the same thing would be true of, and talk just a bit about how aircraft works. Movable equipment, especially internationally movable equipment. Think ships and planes.
Yes.
Right? These are subject to special forms of financings. They're still commercial financings, still secured, still fall in the same category, but we use a different kind of perfection system and notification of lien system, because an aircraft could be literally just about, not entirely, but just about anywhere in the world, right? A large aircraft could literally, be 5,000 miles away in a completely different country, and now what do I do? How do I figure that one out? So talk to them a bit about what we do when we do aircraft lending, secured aircraft lending and title stuff on aircraft.
Well, again, there is a physical title to the aircraft, and there are specific closing agents that will oversee those transactions and work specifically in aircraft deals. And so there's a separate filing system specifically for aircraft. And they will have the system that you log on to, and you see your number that is similar to a VIN number, and it's very similar to a car, but it just has its own filing system.
And who maintains that filing system here in the United States?
The FAA, yes, Federal Aviation Administration. So they oversee it. You can log onto their system. You can see where liens are, and so it's interesting to see.
And where are, you mentioned closing agents, where are all aircraft closings handled in the United States? Where are all aircraft closings handled in the United States?
Are they all in Oklahoma?
Every one of them in Oklahoma City, Oklahoma. Why? Because that's where the filing branch for the FAA is.
Oh, okay. And then, but the physical airplanes are throughout the U.S. and people who buy and sell are located throughout the U.S. and they're the closing agent one area, and you mail the closing documents to that branch either side, and then it's all online that you're seeing, okay, this is my interest, and fortunately we've never been involved in like repossession or how that works, but always once you get physical possession of those assets as the lender, then it's yours to do. Like, you go through the legal stuff, but then there's also then the physical possession of the aircraft or car.
Someone would argue that, and I've never done, you're right, I've never done a foreclosure on an aircraft, for example. But an aircraft is going to be an Article 9 UCC physical asset, subject to Article 9 security interests. The fact that we have to secure that by going through a title filing system through the FAA is no different than having to secure it by going through a local title office here, in the county for purposes, or the state for purposes of a vehicle registration, a motor vehicle registration. Same concept, doesn't matter if it's the FAA or for
local.
UCC Article 9 for secure transaction purposes. Doesn't matter who handles the title records. It's still a physical asset, right? And by the way, that's a misnomer too. The idea that we've got physical assets like tables and chairs you were talking about, computer systems, those sorts of things. Those are easy things. That's tangible personal property. But you have an entire area of the law in secure transactions that's really significant called intangibles, right? Intangibles like, how do I secure a security interest against the most important assets that Microsoft owns?
Right. Intellectual property.
Software.
Yes.
Intellectual property, right? Patents, and not just patented stuff, but secret sauce like the Coca-Cola recipe, which has never been disclosed and carefully protected by dividing that recipe up in all different subparts so no one knows it, right? That's called a trade secret. It's truly the quintessential trade secret. That's an intellectual property item, or a general intangible, they call it under the Uniform Commercial Code, under Article 9. Can you take a security interest against that? Can a bank have a security interest against the Coca-Cola recipe? Sure it can, under the Uniform Commercial Code. So it doesn't need to be, this physical stuff that we can put our hands on, that we can go take possession of, like an aircraft or a ship or something else.
Right.
It can be intangibles too. And so...
And another intangible would be in a bank account.
Right, but bank accounts, you can't take a security interest in money under Article 9. So what happens is we don't get a security interest against money. We actually get
in the account,
assignment, right? Well, even an account, you get an assignment, a collateral assignment of the account, like a collateral assignment of leases, because Article 9 doesn't cover real property interests, guys. Uniform Commercial Code Article 9 does not cover real property interests. And a lease, for example, even though it's an intangible, right, it's a contract right, it is not an intangible for purposes of Article 9 of the Uniform Commercial Code, because the Article 9 does not cover interests in real property or in what's considered money. Right? And an account would be considered money. So the way we take a security interest against
is an assignment.
Is a direct assignment.
Direct assignment.
It's actually an assignment of the interest. And then there's this right back that's given back to the party that's assigning it over. It says, oh, by the way, Mr. Bank, I'm the Mr. Bank. I now have title to your property, but I give you the right to use it until you default on my loan. At which point, I take it off. Right? It's a different way of collateralizing in a secured transaction rather than just using a lien, which is also a very important construct to understand how the differences work. And if you ever get an opportunity to read through loan documents, and I mean, people complain about them all the time. We've got commercial. I held one up the other day in one of the earlier sessions. 150-page multifamily loan document from Fannie Mae or Freddie Mac, right?
Right.
Holy cow! I mean, pages and pages and pages of stuff, right? And you're wondering, what in the world are these people doing? 150 pages later, how can they possibly be spending 150 pages? A book. It's a book.
Yes, and that's because the loan agreement defines the relationship between the parties. Exactly. And so it has to be long because a relationship can include a lot of different scenarios.
Yeah, that's right. And in this case, what we're talking about now is the varied kinds of collateral that can be involved in a given business. That can be tangible, intangible, real property, non-real property, things that have to be assigned as opposed to simply pledged. That would be the difference in the language we use in a secure transaction. I get to pledge the real estate to put a lien on it, but I can't pledge a lease. I've got to collaterally assign a lease to give the lender the rights in that lease. So anyway, there's, as you can see, there's a lot of nuance and a lot of, and as a result, a lot of potential problems, pitfalls, areas where you can step on, as I've said to you guys before, you hear the click. You don't ever want to hear the click, right? We don't want to step on the claymore. And there's a lot of that in secured lending in any and all of these areas. The other thing, talk just a bit about how you handle in secured lending, how you handle the choice of law that applies to the transaction.
There's lots of different options. The lender is going to want whatever laws are beneficial to them. A lot of banks will want where they're located. So it might be a New York bank. They're going to require New York law. It is negotiable. So the lender may allow you to negotiate choice of law for wherever the assets are located or property is located. The borrower may want to try to have the law of where they are located, because what choice of law means is that proceedings then will occur wherever the choice of law is designated. So it may be New York, it may be Texas, and if it was Texas and the borrower is located in Texas, they might feel like they might get preferential treatment or breaks in those proceedings. So the borrower is going to want where they're located, the lender is going to want where they're located, but generally in land, it's where the property is located. So if it's an apartment complex in Alabama, the mortgage is going to be that state, but the loan documents, they could be, like other issues, could be another state. And so it's important to like look at every document individually and to know generally it could be a lot of different things.
And how would, outside of the issue of jurisdiction, which is what you're talking about,
Yes.
right? Outside of the issue of jurisdiction, why would choice of law in the underlying loan documents, not the mortgage, you pointed out that probably applies to the state in which the property
is located, yes.
It's real property. But outside of that, the issue of jurisdiction, in other words, where are the parties going to argue if they've got issues? Outside of that, what's important about about choice of law in the underlying loan documents?
Choice of law is important. Why is it important?
Yeah, why is it important?
Because laws can change or be drastically different in different states. So lending maximums for interest in Texas, there's maximums and requirements and there's protections for the borrower available. Not all states have that. So choice of law is very important to pay attention to and to know. And if you have the ability to negotiate more borrower-friendly states, you want to do that. And not always is that possible. So there's also, for movable property, when you're securing that interest with the financing statement, it has to be secured not only in the state in which the property is located, but it also has to be secured and filed in the UCC filing statements of the state in which the business is located. So if we're located in Texas, you'd file the UCC here, and then you'd also file the UCC wherever the movable property is located, whether that be Alabama, New York, wherever.
Yeah, so that's absolutely right. That is to say, choice of law has a significant effect. In fact, it establishes the basis for the relationship between the parties in the contract.
Yes.
Just because the contract words say something, we doesn't mean we know for sure what it means under the state law that's chosen for that contract. So as Tabitha's pointed out, if we choose New York choice of law in a loan document, the laws of the state of New York are going to apply, and there are massively different lending laws in the state of New York than there are in the state of Texas.
Yes.
Completely different, very, very different. The same thing would be true of a choice of law in California, massively different in terms of borrower interest protection. You're talking about usury. That's called usury, is limits, interest limits. Things like jurisdiction over property, procedural things. How
quickly, yes,
work.
how quickly the lender can step into the borrower's
Those
shoes.
Things. All questions of state law in which the choice of law is determined. So anytime you see that, and by the way, choice of law is always one of those boilerplate items that's way at the back of the document in that section that nobody reads, right? And there are a couple of provisions, Tabitha can tell you a couple of them, but there are a couple of provisions that instead of reading the beginning of a document, you ought to go all the way to the back and look down through those and check and see where you are first to get perspective, and then go back and read your document. And choice of law is the very first one. You should check every time to make sure you understand what law you're in, and then make sure you get a lawyer that's licensed in that jurisdiction and knows what in the world they're talking about to address the issues that would be peculiar to the laws in their state. So don't forget that in a lending transaction, whether secured or unsecured, by the way, or in any contract situation. It's not just lending. Lending happens to be a series of really complicated, sophisticated contracts. And many times we think we can't negotiate them. And sometimes you can, and choice of law is a difficult one. Most lenders don't want to negotiate choice of law for good reason. right? They know their laws, they know the laws they operate under, what they're licensed under, and how they're going to operate. But that doesn't mean that the issue of jurisdiction that Tabitha was talking about earlier can't be negotiated separately. Just because I've got New York choice of law does not mean I have to show up in New York for court. I can show up in federal court in Dallas, Texas, if I belong here, and there's diversity of jurisdiction between the citizens, and I can bring the case right here, unless there's a jurisdiction clause in the loan document that says, hey, the parties have exclusively agreed, we're going to show up in New York, in Manhattan, or wherever, right? You have to look at every one of those issues, but they are critically important to figure out how the law is going to read and apply in any given loan transaction. You don't know until you've looked at it and really looked your way through the law that applies there. There's a lot of that in this kind of game, and there's a lot of different lenders that are using different state laws, and they're entitled to do it, but you need to be paying attention to that when you're doing a secured lending transaction of any kind. Yeah. What about ships? We've never done one, by the way.
Yes,
I've been involved in a few, but we've never done one, so that's an unfair question to ask her. But there's another filing agency, and she's aware of it. She just hadn't told us about it yet today. There's another filing agency that handles international movable collateral, including aircraft. What's the other registry we file under when we do aircraft?
Oh.
Do you remember?
No, I don't remember.
I'm testing her. It's not fair. She hasn't done very many. It's called the International Registry.
Oh, yes.
Yeah.
The IR.
Yeah, the IR, right. The International Registry. So tell us a bit about the International Registry and how that works and kind of where that is.
Well, with big movable items, planes and then boats, there's an international registry that puts the world basically on notice of where these, like who has interest in these big items, and their details. So.
Do you remember where it's located? Do you remember where it's housed?
Oh, isn't it in the UK?
Ireland specifically.
Yeah. So it's always nice to call them because they have a wonderful accent. Very nice. So.
So you have to look two places, really. You have to look at the International Registry, then you have to look at the FAA's registry, right?
And is there, for boats, is there a U.S. Registry system? Do you know?
I don't recall there being a U.S. registry system for boats. And by the way, your little local motorboat that's out on the lake somewhere, the answer is no. We're talking about international moving stuff, so we're talking about
big
yachts
ones,
and large craft, sea craft. And most of those, because of the way the laws are written, now we're back to the law again. Why are we always talking about the law? Lawyers are up in front of you talking about the law all the time. Because it governs everything around us and everything we do. And the more we know about it, the better we're able to do the things we'd like to accomplish. That's why we need to know the law. So anyway, back to movable property and ships. Most boats, most large ships, including yachts, are not registered under United States law. They're registered under offshore, most of them island, but some of them places like, this is an island too, Malta law. You'll find ships chartered under Bahamian, especially the Bahamas, Bahamian law. That is where they'll get their registration done. So you just anyway, and I'm not quite sure why that is, other than that I think these small island nations, first of all, they're looking for revenue, and secondly, their laws can be written in a way, because they're island nations and they're used to being around water and have water trade and have for hundreds of years, they have an established set of laws and court decisions that have determined the rights of parties with respect to the ownership and collateralization of vessels, and what the rights of vessel owners are and those who work on them and all those sorts of things. Very developed area of the law in those countries because they deal with it all the time. It's just who they are. And because of that, that's where all these major ships, great big massive ships, virtually all of the cruise liners are all Bahamian registry or Bermuda registry or other registry offshore. Nothing is registered, under U.S. law for a variety of reasons. So back to the IR again, that's what we're really talking about, is secure transactions. As a result of that, there was developed a need for, especially as finance during the 70s and 80s got much more global. People out of London were financing things from all kinds of places all over the world. There became a need to do more than just have a filing system in London. And pretty soon, the Asian banks all had the same problem, and it was all registered in Singapore, but you need to do more than this. And so ultimately, a number of the advanced countries came together and created this international registry. And it's now recognized across the globe. Every significant lender of any kind at all that lends into this kind of movable collateral, they all require IR registration. And it takes a few days. That's one of those things you have to be out on the front end of. It takes some time because the borrower has to register and get a number and those sorts of things. It takes a little time to get that turned around and come back to you so you can actually do an IR filing. And we've dealt with that in some of our aircraft work that we've done. So anyway, just more on secure transactions and understanding, kind of getting outside of this little box of real estate or business lending. There can be a lot more to it. Just be aware of it. Fun stuff.
Yes. Any questions?